So let me just ask to make sure that I understand the limits of what you're prepared to say. Who won the 2020 election?
Senator, as I indicated in response to questions from Senator Blumenthal, Justice Ketanji Brown Jackson, as a sitting circuit court judge at the time of her nomination, was asked this question in questions to the record.
I'm asking you the question.
Yes, and as a sitting judge, I will tell you that it is not appropriate for a judicial nominee to engage in discussion regarding a matter of political controversy with that.
A routine confirmation hearing takes a sharper turn when questions about judicial restraint collide with accusations of selective engagement in public controversies. What begins as a debate over recusal standards soon evolves into a broader test of consistency, impartiality, and public accountability. As tensions rise, both sides press competing interpretations of a judge's role in politically charged disputes. Subscribe for full coverage and analysis.
Mr. Traynor, I just want to follow up on my colleague's questions and make sure that I understand this. You were asked a series of questions about January 6th, and correct me if I'm wrong because I was not here at the time you were asked those questions, and you declined to go into whether this was an insurrection, the nature of the attack on the Capitol, because you said it might involve a case of controversy that would come before you. Is that correct?
Senator, it did involve cases or controversies. We had people in the District of North Dakota that I believe were charged.
So you felt it wouldn't be appropriate for you here today to discuss your views on what took place on January 6th, is that right?
I stated that what I saw was deeply troubling, Senator. The attacks on law enforcement, any attack on law enforcement should be condemned.
So why are you reluctant to answer questions about what took place on January 6th? On the one hand, and on the other hand, you say judges don't forfeit their First Amendment rights. You feel free to write to a university to tell them who they should hire or not hire, who you're going to hire or not hire. You feel free to immerse yourself in that controversy. But here you won't talk about your views of January 6th. Can you reconcile that for me?
Yes, the difference, Senator, is that there is no case or controversy with regard to hiring of law clerks, but handling matters.
Well, you're saying there's no case or controversy involving Columbia, involving the efforts by the administration to punish Columbia, all the litigation around Columbia. That wasn't the case or controversy?
That was.
By this stage, the exchange has moved beyond the events of January 6th and into a broader argument about consistency. The senator is challenging the nominee's distinction between commenting on hiring practices and declining to discuss matters tied to active cases. The significance of this moment lies in how it frames the hearing's central question. Where should the line be drawn between judicial independence and public engagement?
It's far afield from the letter that was signed, Senator.
Really? Why is it far afield? Weren't you complaining about what was taking place on the Columbia campus, and as a result that you weren't going to hire law clerks and the other judges on your letter weren't going to hire law clerks? Wasn't that the nature of your correspondence?
Yes, that was the nature of the correspondence.
So you feel perfectly free to immerse yourself in that, exercise your First Amendment rights there. But when it comes to asking you basic questions about January 6th, you won't answer those questions.
The difference, Senator, is that there are cases or controversies that I have before me as a district judge relating to individuals that have been charged for conduct that occurred on that date in this Capitol.
So does that mean that any litigation involving Columbia you're prepared to recuse yourself from?
Senator, the limitation on Columbia was in regard to hiring law clerks. I hold no bias against the institution itself.
Well, whether you hold a bias towards it or not, you're saying today that you can't discuss any of the January 6th stuff because there are pending cases or controversies, even though they've all been pardoned by the president. I'm not sure what case or controversy you're referring to, but nevertheless, you're unwilling to say you recuse yourself from a case or controversy involving Columbia when you specifically weighed in there. How do we reconcile that?
Well, Senator, as I stated in the recusal order that Ranking Member Durbin raised, I indicated that I held no particular bias against.
Well, yeah, that's fine. You can say you hold no particular bias about January 6th, too. I mean, it's easy to say. Your letter demonstrates a very
The discussion now shifts toward recusal, impartiality, and public perception. Rather than focusing solely on legal standards, the senator argues that prior public actions may create concerns about neutrality. This marks an escalation in the hearing because the debate is no longer about a single statement or decision. Instead, it becomes a wider examination of how judicial conduct can influence confidence in future rulings.
Clear bias. I'm not saying that it's an unreasonable bias, but it is a bias. It is a prejudice in favor of one view that would cause people to question your impartiality if that case came before you. That seems to me a stronger, much stronger case for recusal than the one you're making to refuse to answer questions about January 6th. So let me just ask to make sure that I understand the limits of what you're prepared to say. Who won the 2020 election?
Senator, as I indicated in response to questions from Senator Blumenthal, Justice Ketanji Brown Jackson, as a sitting circuit court judge at the time of her nomination, was asked this question in questions to the
Well,
record.
I'm asking you the question.
Yes, and as a sitting judge, I will tell you that it is not appropriate for a judicial nominee to engage in discussion regarding a matter of political controversy with that.
See, this is completely inconsistent with your involvement in the whole Columbia controversy. Completely inconsistent. Because you involved yourself in that controversy. You went out of your way. Nobody asked you to write that letter. You took this upon yourself to do, to insert yourself into that. But you're saying here, you can't answer a simple question about who won the 2020 election because it would somehow implicate you in controversy. I'm sorry, there's no way to square those two things. Mr. Chairman, I yield back. I just wanted to add on to what Senator Whitehouse was saying. In the Central District of California, we have no U.S. attorney.
The confrontation reaches its most direct point when the senator presses for a straightforward answer regarding the 2020 election. The nominee responds by emphasizing the traditional caution expected of judicial candidates when addressing politically contested matters. This exchange highlights a recurring tension in confirmation hearings, balancing transparency with the expectation that judges avoid comments that could later call their impartiality into question.
We have no acting U.S. attorney because the person who was acting, their tenure expired, and to get around the confirmation requirement, they have been made the first assistant U.S. attorney and are presumptively running the office from that post. This is someone who has demonstrated their unfitness for the job by going into the grand jury so often. His name is Bill Asaley, and getting a no bill, that is the grand jury refusing an indictment when the bar is only probable cause, that they have taken to calling him No Bill Asaley. It was reported in the LA Times that he was heard shouting at the Justice Department over the phone within earshot of the grand jury, vis-a-vis the Justice Manual's requirement that you don't seek an indictment unless you believe you can prove beyond a reasonable doubt someone's guilt at trial, shouting at the Justice Department over the phone that they can F the Justice Manual. And this is who's left in charge of this office, this very important office. So I just want to acknowledge the concern that Senator Whitehouse raised, and because we're seeing very much the same problem in California. Thank you, Mr. Chairman.
Over the course of this hearing, the focus evolved from questions about January 6th into a much broader debate over judicial ethics, public engagement, and institutional trust. The senator's argument centered on consistency, suggesting that public intervention in one controversial matter makes silence in another more difficult to defend. The nominee, meanwhile, maintained that active legal responsibilities require caution when discussing issues that could intersect with present or future litigation. The exchange also illustrates the difference between legal and political frameworks. Legally, judicial nominees often seek to avoid statements that could create questions about impartiality. Politically, however, elected officials frequently argue that the public deserves clear answers on matters of national significance. Those competing expectations often collide during confirmation hearings, creating moments like the one seen here. Beyond the immediate disagreement, the discussion reflects a larger national conversation about the judiciary's role in highly polarized times. Questions about recusal, public statements, and judicial independence continue to shape how courts are viewed by the public and by policymakers alike. As always, the significance of these hearings extends beyond any single exchange, offering insight into how future judges may approach some of the most contested issues facing the country. Subscribe for continued coverage and analysis of the debates shaping American institutions.